Hey everyone, welcome back to another episode of Not Crazy, Just Complicated, your criminal law companion where we unpack the widest legal defenses with just the right amount of caffeine and chaos. Today's topic, automatism. Yeah, I know, sounds like something out of a sci-fi movie, but it's real, and it's actually one of the most fascinating defenses in Canadian criminal law. So let's talk about what happens when someone says, I committed the crime, but I wasn't really there when I did it. Automatism is when your body is doing something, sometimes even complicated things, but your mind is completely checked out. Think sleepwalking, a seizure, a dissociative mind state. You're moving, talking, maybe even driving, but you have no awareness or voluntary control. Legally, this is a big deal because it challenges actus reus, the physical part of a crime. Remember, you can't be guilty of a crime unless your actions were voluntary. As the Supreme Court said in Parks, automatism isn't just a quick defense, it's actually part of the foundational requirement for criminal liability. So, if you are an actual automation when it happens, maybe you shouldn't be criminally liable at all. Here is where things get juicy. Automatism comes in two flavors. First, mental disorder automatism. This means your involuntary act came from a disease of the mind. Second, non-mental disorder automatism. The act from something external and contemporary, like a concussion or sleepwalking. Why does this matter? Because if it is a non-mental disorder automatism, you walk, full acquittal. If it is a mental disorder automatism, you found not criminally responsible and go through the usual NCR process, assessment, review board, and possible hospitalization. So you don't just have to prove that you're a zombie, you also have to convince the court that you were the right kind of zombie. Now, you might be wondering, why is the law so strict about this? Well, two reasons. First, automatism is easy to fake. If every I back out story ended in an acquittal, we will have chaos. Courts want to make sure the defense is legit, not just a convenient excuse. Second, public safety. If someone acted involuntarily once, what's stopping it from happening again? That's why courts often treat these cases as mental disorder cases by default, especially if there is a risk of recurrence. In Stone, the SCC pretty much said, look, most cases of automatism are mental disorder automatism, so we're gonna need stronger proof to believe otherwise. How do you prove automatism? First, the burden is on the accused. That's right. If you're saying you didn't act voluntarily, you have to prove it. And the bar isn't just raise a doubt. Nope. You have to show on a balance of probabilities that you acted involuntarily and the cause was something other than a disease of the mind if you're claiming non-mental disorder automatism. And before you even get into a jury, the judge has to agree there is enough evidence to make automatism a real issue. Just saying I blanked out won't cut it. You will need expert psychiatrist evidence, a clear, believable trigger, ideally a history of dissociative episodes, and bonus point if there is no motive for the crime. So how does the court decide whether it is a mental disorder automatism or a non-mental disorder automatism? Two tests help. The first is an internal cause theory. Would a normal person in your shoes have reacted the same way? If no, it's probably a mental disorder automatism. And second, continuing danger theory. Is a condition likely to happen again? If yes, it's a mental disorder. These are legal tests, not medical ones. In fact, as the court said in the Luedecke, we don't even use mental disorder the same way doctors do. It's not about diagnosis, it's about how dangerous your condition can be and whether the law needs a way to manage that. What happens if it's accepted? If the jury accepts your defense, if you're found mental disorder automatism, you're acquitted, you're free to go. And if you have found mental disorder automatism, you found NCR and head into the review process for mental health related dispositions. But if the judge says your evidence doesn't meet the air of reality standard, no automatism for you. Back to regular criminal trial. And even if it goes to the jury, they may not be convinced. The burden is on you, remember? So, what did we learn? First, automatism is a defense based on involuntary action. If it is proven, it undermines actors' risk. But in order to win, you need stronger evidence and probably a good sleep disorder expert. Most cases end up as mental disorder automatism, leading to NCR rather than outright acquittal. The court are cautious because of the credibility and public safety concerns. At the end of the day, automatism is real, but rare. If you're going to use it in court, you better have more than just "I blacked out." And thank you for listening to this episode of Not Crazy, Just Complicated. Stay sharp and stay conscious, unless you are sleepwalking, in which case, maybe see a lawyer.